Quick show of hands, who here is a law student? Awesome. Well, congratulations. And that kind of helps just frame the conversation a little bit for me in my head. So today's panel is on consumer protection and the intersection with immigration. And we've got two excellent panelists with us who I'll introduce, or really allow themselves to introduce themselves in just a moment. So my name is Leland Baxter-Neal. I'm the Director of Community Lawyering and Movement Building at Oregon Consumer Justice, a nonprofit that's a statewide nonprofit but based in Portland. My background is in largely immigration work. And so I mentioned earlier that I graduated from U of O in the journalism program. While at U of O, I studied abroad in Mexico, which was really kind of a life-changing experience, and I spent most of the rest of my 20s living in Latin America and working as a journalist. And upon returning to the United States, I started working for an immigration attorney as a legal assistant, which led to law school. And over the next almost a decade, got involved in immigrants' rights organizing and legal advocacy, doing some practice of immigration law, direct representation, some program development at a public defender's office. I had the opportunity to be the immigrants' rights attorney for the ACLU of Oregon for a few shining years during the Trump administration, and most recently worked at Latino Network, a community-based organization on policy. And across that time had the opportunity to work with so many amazing advocates and organizations, coalitions, advancing justice for immigrant rights. So it's really exciting to be here now in my role of consumer protection, moderating this panel on this intersection. And so I want to first introduce Bryce Newell to my left, who's a professor and has a fascinating background. So Bryce, I'll hand it to you to introduce yourself.
Thank you, Leland. It's nice to see all of you today. Thank you for being here. Thank you for interest in the topic. I'm an associate professor in the School of Journalism and Communication. I often refer to myself as a recovered lawyer. I'm not never much of a lawyer. I don't practice very briefly. I went to law school in California and then decided I wanted to do research and teaching, and so I went and got my PhD. So I'm trained in law and got my PhD in information science, largely as a social scientist. So my research, I'll talk briefly about sort of the purpose of some of the research here that's been funded through the Consumer Protection Grant Program. Or it's being funded. It's actually a current project that was just funded this summer, and so it's sort of in the early stages, and so we're talking about some of the broader issues there. But I have done research focused on immigration and work on immigration since just about the time I finished law school back in 2010. And throughout my PhD and the subsequent years, I was doing research with a number of migrant aid organizations in southern Arizona and southern California, particularly in the Tucson, Nogales area. And I did a lot of research looking at the ways in which those groups, such as the Samaritan groups, water and food out on the migratory trails, the Jesuit organizations that run shelters in northern Nogales, Sonora, and so forth. So we're doing research with them, looking at the ways in which they produced information, accessed information, used technology in order to serve the migrant populations that they were working with. And then also did interviews with migrants as well, recently deported migrants who have been deported to Nogales, or those who were coming from further south and were contemplating a clandestine crossing across the U.S.-Mexico border in northern Arizona, from Sonora into Arizona or into Southern California. My other line of research has largely been focused on police surveillance and privacy law, and I did a lot of ethnographic field work with police agencies and the adoption of body-worn cameras. And so this project here, which is really about looking at kind of tying these interests of mine together, it's focused on thinking about how, particularly this new wave of consumer data privacy laws that we've just had adopted in Oregon that becomes effective at the beginning of next year, and that we're also seeing sort of adopted in fairly rapid succession in a number of states. We have 12 states that have adopted these statutes in just the past couple of years. since 2018 when California adopted their Consumer Privacy Act. And so in just a very few years, we've seen a lot of states adopting these laws. And so part of this project was thinking about what impact do these laws have, what benefits do they have for immigrant communities living within the states, within Oregon in particular for this project. And then how can we think about data privacy law more writ large within consumer protection, but also more broadly, in its relationship to sort of the stated sanctuary policies of states like Oregon and Washington and so forth, where we have state-level policies. And Oregon is the first state to have a formal declaration of sanctuary status as a sanctuary state. I think that Leland will talk a bit more about some of that history in a few minutes. But drawing on those perspectives, those commitments, what could that look like? How could that inform data privacy law? And how can we think about data privacy law in ways that both supports, empowers, and protects the rights of immigrants and other immigrant communities within Oregon? So that's sort of the nature of the work that I'm doing this year and will be continue doing, hopefully at this point next year. Maybe if I'm invited back, I'll have a lot more to say about what we actually found out. I'm thrilled to be here, and I'm looking forward to the conversation and to the conversation we have with you all as well.
So I also want to then introduce Lidia, Esther, Munoz, Paniagua, a researcher, and I'll let Lidia introduce herself.
Hello everybody, thanks for being here. As you heard, my name is Lidia Munoz. I am Mexican. I am an anthropologist and also a musician, but I'm here as an anthropologist, not as a musician. I play the cello. Outside academics, I'm a mother of 3, which keep me busy, and I'm married, so I share that responsibility with my husband. And as an anthropologist, I have done research in areas like labor. That has been kind of my major focus of research, but I have, well related to that, I have done a lot of research into informal or formal markets, gender equality, and immigration. And specifically now, I'm kind of in that intersection between immigration and labor. And a little bit you'll probably hear more about during this panel is my main research interest. That's the H2 program, which has been kind of my main focus of research for the last 10 years, and to which I came very kind of by accident, right? I was hired to do as a research assistant in Mexico to do some research with recruitment agencies for H2 workers in Monterrey, where most of workers used to process their visas. So that's how I came involved with the research, and it really has captivated me for the last 10 years. I'm a very curious person, so I'm interested in a lot of things, but some of the issues that this population share among them is really what has kept me insisting on doing research in this area. So I'll talk to you a little more about it in the following minutes.
Great, thank you. And so how we're going to do the panel today is I'm going to have a conversation with each of the panelists, drawing out some of the main topics and themes for their research, and then getting a little bit into the specifics of what they're researching. So Bryce, I'm wondering if you could, I guess, begin by kind of what are we talking about with digital privacy and data privacy as concepts and as consumer protection concepts?
Thanks. So data privacy is really sort of it's come into fashion in the past several years. I mean, in the past we would talk a lot about information privacy in the US, data protection in Europe and many other parts of the world. And lately, I think largely within the consumer protection space, we're seeing this term data privacy emerge. CCPA in California, now we have the Oregon Consumer Privacy Act, and as I mentioned, 10 other states beyond those 2 that have adopted these sorts of statutes now that generally talk about personal data, protection of personal data, restricted processing. So there's some links here in an evolution from sort of a broad sectoral approach to information privacy and other types of privacy in U.S. law that's sort of been split by sector at the state and federal level. Now we're thinking about it in a way that's in some ways started to import some ideas from data protection in Europe and in other places. But it's largely, again, about restricting the collection, the use, and the dissemination or sharing and selling and so forth of information that relates to people. And so in this context, immigrants and others who might, who are, whether they're visa holders whether they're green card holders, whether they're undocumented, right? The information can relate to people, data can relate to people in a variety of different ways. And this new wave of consumer protection laws are really trying to address many of those issues within, of course, the consumer protection context.
So your research concerns in part the application of legislation passed just this past session, championed by the Attorney General, that enacts comprehensive data protection or data privacy protections. What should we understand about this bill and how it fits into the larger national and really international framework around digital privacy and data protection?
Sure, thank you, good question. So first, can I just ask for a raise of hand, how many of you have followed at all sort of the adoption of sort of this new data privacy, Oregon Data Privacy Act? Several that we would expect. Yeah, okay, so a lot of you may not have followed too closely. It's a process that was championed and initiated, and this sort of bill was recommended to the legislature through the Attorney General's office during a process of, well, a couple of years, but it sort of got sidetracked during COVID, and they worked on some other things. There was some data broker registration rule requirements a couple of years ago, and then they were working on some contract tracing privacy legislation, and then came back to, sort of in the last year before this last legislative session, this issue of a broad consumer data privacy law. And so it is a consumer privacy focused law, but it does a lot of things in terms of the entities, individuals, companies that are subject to it sort of are essentially covered under the statute. Have a host will have, it's effective as of January 1st of next year, will have a host of requirements that they have to abide by. There's some consumer rights that are built into this, largely to be protected through actions by the Attorney General's office itself. It was initially proposed with a private right of action, that language that came from the Attorney General's working group. That was stripped out during negotiations when it was in the legislature, so we lost that. I think there's reasons to think that the private right of action that was included wasn't terribly robust anyway. I think it was a practical calculation about what is likely to potentially get there, potentially get some traction in the legislature. We've seen that in several other places as well. None of the existing statutes that have been adopted or in force yet, or in other states, have a private right of action beyond things like data breach notification, which California has, and several others. There have been other proposals. We'll see where that goes. And maybe that's one area where we can see some movement again in the future. But I think this is interesting because, on one hand, it's a good step forward for thinking about data privacy rights for Oregonians in terms of thinking about the data that's collected by companies and organizations that we engage in commercial transactions with, right? That we buy goods and services from. We have some rights. There's some certain protections, and the Attorney General's office can initiate investigations and proceedings right in accordance with the law, which is useful because we haven't had that, and in the U.S. in general we haven't had that at all outside of at all really until 2018 when California was sort of the first to do this. And so it starts. One of the things that I would kind of cautious about this though is that it's often framed in terms of these as being comprehensive data privacy statutes or compared to something like the GDPR in Europe. These are very different, and I think for reasons we may or may not have need to get into too much here, but it really follows that consumer protection, the consumer business, the business-consumer relationship, where the data protection statutes really follow sort of processing much more broadly. There are fewer restrictions on what entities actually have obligations under data protection laws and so forth. But I think it's an important step forward, and actually some other work I'm doing with some colleagues, I think there's a lot of benefit to having specific consumer protection, or privacy laws in the consumer protection space. But we ought to see them, I think, in other places as well, right? In other aspects of other areas of law as well. But again, it's often framed as a comprehensive data privacy law. The International Association of Privacy Professionals provides a really nice sort of tracking list of all this existing legislation. It's moving through legislatures around the country, as well as which ones have been adopted, with links to the statutes and the bills and so forth. They frame it as their inclusion is they include statutes in that listing by virtue of what them being comprehensive. But again, I would challenge that. They're comprehensive in many respects within a particular consumer protection framing within the consumer protection law, but there's a lot that they don't cover. So I think that in terms of my thinking about how can data privacy law, better support and protect immigrants' rights. I think that consumer protection is an important primary space without we see movement there. There's something to build on, but we also need to think more broadly, I think, than just within the consumer protection space for that.
So that's frames up, I think, the next question. Your research raises this concept of a digital sanctuary, which I'd like to get into, but I think before that, I want to frame up for the folks here the idea of sanctuary as it's often used in terms of sanctuary cities and sanctuary states. The Attorney General sort of mentioned earlier the legacy of Oregon being known really for such strong reproductive justice, like a legacy of reproductive justice and protection of reproductive rights. Oregon also has a legacy of having some of the stronger sanctuary, quote unquote, laws in the country. I think first Oregon was the first state to enact a statewide sanctuary law, and I keep putting it in quotes because sanctuary isn't really a defined term. What most people mean by sanctuary is that there's some limitation, that state somehow limits the enforcement of federal immigration law in that state. And immigration law, I think of it sometimes in two pieces. There's the affirmative side and there's the defensive side. And affirmative is like when someone goes to the government as an immigrant or relative of an immigrant and says, I want to avail myself of some immigration benefit, a visa, immigrant visa, non-immigrant visa. The defensive side is when the government comes at you and says, we want to enforce immigration law against you, which ultimately means detention and deportation. And for folks who advocate for sanctuary type protections, and I'll name myself as one of those advocates, we view that detention and deportation system as deeply dehumanizing, harmful, and unjust. And these sanctuary, what often gets grouped as sanctuary are really efforts to limit the enforcement of federal immigration law, but particularly state cooperation in that system. It's rooted in a couple of ideas, right? Both the supremacy clause about where federal law gets to reign supreme, balanced in the 10th Amendment, particular principle called anti-commandeering, where while there is a federal government, there are also state governments with state constitutions to whom police powers and other powers are reserved. So in that balance, there is the ability for states, currently recognized under pretty standard constitutional law, to really have the authority over what their law enforcement does. And so states can pass laws that say this is what our law enforcement does. Anti-commandeering is about the federal government cannot commandeer the resources of a state, like, oh, your police officers are now federal immigration authorities, if that state disagrees. So there's a program, for example, called 287G that the federal government uses to deputize local law enforcement as like junior ICE agents and put them out in the field to apply all of their expertise in federal immigration law in identifying folks who may be subject to enforcement. So Oregon was one of the first to pass a statewide sanctuary law, and what it essentially did is it prevented that direct enforcement by police of federal immigration law, but it left all sorts of room through some vague language for other types of collaboration. What that really has looked like over the years is jails being the first step in people moving from just their general lives into the immigration system, because as police would gather information, they would then pivot and hand that information to ICE, being like, hey, we've got someone, sometimes based on name and look alone, they're a facility with English. And we were able to, through the passage in 2021 of HB 3265, the Sanctuary Promise Act, to enact what is now really the absolute strongest sanctuary law in the country. I recently saw a map that compared Illinois and Oregon were sort of both, but I think Oregon's smaller, so we get the plus on that. Lots of gaps as well, but it does things like prohibit any public entity from gathering immigration information, country of birth, things like that. If there's not a benefit that's not necessary to some benefit that person's seeking, it prohibits public entities from cooperating with ICE, from sharing that information with federal immigration authorities. Does a bunch of other things. It created a hotline. It prohibits jails from running detention centers for ICE, and it prohibits ICE enforcement in and around our courthouses. So framed up, right, sanctuary, right, as this idea of the state's ability, or even a city or county's ability, to limit their resources from being used in federal immigration, but often thought of as sanctuary, right? Like this state is protecting people from something. I want to then now ask you, what does digital sanctuary mean, and how does it play into what you're looking at?
Yeah, thank you, Leland, for that. I think that's really helpful. So, some of the ways in which data information, sort of digital, in the digital context, sort of plays into this is that some of the things, right, it's about some of the restrictions that Leland was talking about are essentially that law enforcement and other government agencies shouldn't, and now even ask for, right, they're limited in the ability to even ask for place of birth, nationality, citizenship status, those sorts of things when they contact people, state law enforcement, right? State agencies shouldn't do that. They shouldn't share or disseminate that sort of information. They shouldn't collaborate then with law enforcement. And I think that a lot of that relates to information sharing. One example of sort of, I think, how this gets into sort of the data privacy space was several years ago. I think it was 2017 when Oregon passed a law providing driving license privileges for undocumented individuals here in Oregon. Shortly after that, it was shown that the Oregon DMV had signed contracts with LexisNexis and Thomson Reuters in order to sell DMV information to those agencies to do background investigation, to provide data for background investigations and a variety of other things, right? And so they were essentially, we were putting undocumented individuals into that database, and then the state was selling that to commercial agencies, commercial companies. Sanctuary for a long, generally, is about the relationship between sort of, state and local governments and federal, right? It's about restricting, as Lou said, the ability of state public actors from engaging in immigration enforcement at the federal level, supporting those sorts of efforts, providing that information. Along the lines of this data transfers and this data sales, right, the commercial data market that's grown up in the U.S., we also see, and there's been a lot of revelations over the past couple of years about how ICE in particular, CBP, ICE, Homeland Security, have been buying lots of these databases from Thomson Reuters, from LexisNexis, from utility companies, conglomerates of utility companies that pool their data for various reasons related to sort of risk detection and sort of being able to offer products and services and utility to their customers, including in Oregon. But the data is then being packaged and sold on the commercial data markets, and it's being bought by federal immigration authorities. And so one of the things that, because it's early in this process, but one of the things that we're planning to do in this project that I've gotten funding for this year is to investigate other places and ways in which governments are participating in selling information to these commercial data exchanges, these commercial data markets through a variety of methods, including public records requests to state agencies and a number of public agencies around the state, right? But unpacking exactly where this data is flowing from, what sorts of information about Oregonians, but also about the immigrant populations are potentially contained in this data, because it's sort of an indirect method of interacting with and providing that information to, amongst others, federal immigration authorities, and so it can be used in that way. And so digital sanctuary, as I framed it, and there's other scholars who've talked about sanctuary and digital sanctuary in related but slightly different ways, is really about thinking about sanctuary in the informational terms of data, in terms of data flows, data sharing, commercial data markets. How can we regulate those in order to really uphold the same sorts of commitments that we have about not facilitating, but many see it, and I would amongst myself, I count myself among this, right, as unjust immigration policies and procedures and so forth that have existed for decades here in the United States, right? And so under that framing, it's really about focusing on the data flows, where that's coming from, in which ways is that may even indirectly making its way into the hands of immigration enforcement authorities.
And so think we're just about at time for this discussion. I want to just give you a couple, like a minute or two. Anything additional you want to share about your research and kind of how all these things come together and what you're looking at?
Sure. I mean, I'll be brief. I hope we can have some broader conversation. I'm looking forward to hearing the conversation with Lidia as well. There are several sort of low-hanging fruit in terms of just thinking about the consumer protection law the Oregon Consumer Privacy Act that's going into effect in January. That law, for example, defines, so the only place where citizenship or immigration status shows up is really in the definition for sensitive data. And so sensitive data receives some heightened protections under the Act, which essentially means that it can't be processed, collected, used, analyzed, sold, and so forth without consent. There's a definition of consent. Consent, I think, is a very problematic frame. I'm not alone in that. There's a lot of privacy scholarship all over the place that sort of talks about the problems of really trying to figure out what is informed and willing consent particularly in the digital context if you're interacting with someone you might buy goods from. What exactly does informed mean when we never read these terms and so forth, right? So it all hinges on consent, and I think there's ways about pushing back on that and trying to solidify a bit more rigor in terms of protecting this sort of sensitive data as well as other types of data. This Oregon's Data Privacy Act looks a lot like acts that have been adopted in quite a few of these other states, Virginia, Colorado, Connecticut, Utah, and so forth. They're sort of built on the same model. And one of the things they do is explicitly, not just, they don't limit essentially, they actually explicitly authorize and empower corporations to share data with law enforcement, right? And so there's ways I think in which we think about, well, thinking about restricting the ability for corporations and private entities from interacting, engaging with the federal government is a little bit different than thinking about sort of the nature of the state's relationship to the federal government. But there are ways, I think, in which we can look at, even in this particular piece of legislation, about ways to improve that, to put more checks and balances in place, to limit data sharing in some of these contexts. Just my final example here is that one of the only ways in which Oregon's sanctuary laws really allow the state agencies to facilitate to work with the federal immigration authorities is when there's an arrest warrant, for example, and they need to sort of, and so there's some exceptions for that. The provisions in authorizing data sharing here go way beyond that, including allowing corp companies to share data with federal law enforcement if they have reasonable basis to believe that there's some legitimate need that the government might have, right? Essentially, so it's very broad. And so I think those are just some of the low-hanging fruit, but again, hopefully we'll find a number of other areas or ways we can think about improving the ways in which we protect these data flows and data information about this very vulnerable population here.
Awesome. Thank you, Bryce. And with the limited time, I'm just going to turn now to Lidia. I'm excited to hear about the work you're doing. So this is really kind of now pivoting as well to the other side of that immigration binary of the affirmative side, right? Where folks are trying to work through immigration benefits, which is largely basically structured through a visa system. And there's a non-immigrant visa side and an immigrant visa side to that system, right? And immigrant visas are generally almost entirely based on family relations. So people who have some connection to the United States may be able to then, through that connection, bring additional family members immigrating into the United States. But your research is really more about the non-immigrant visa side. So I'm wondering if we could start with talking about what is the H-2 visa, how does it differ from other types of visas in the immigration system?
Yes, thank you very much. So the H-2 visa, does anybody know what an H-2 visa is? So an H-2 visa, which is sometimes more than what I usually get. The H-2 visa is part of like what we call the managed migration scheme. So it's like these are migrants that are coming to the U.S. with a legal document, aka a visa, but they with like specific limitations. Mainly, they can only come here temporarily. So most of them, for the H-2 visa, they can come from 1 month to 11 months or 11 and 15 days like duration of their visas. So this visa program specifically was lobbied into law in 1952 to admit low skill, and I will use this, low skill labor into the USA. And its creation responded to the interest of a very specific group, that the growers associations that tend to be powerful in US legislation, and specifically from sugarcane growers in Florida. So that kind of gives you a context of what type of workers were these people lobbying for, right? So it is very important to not lose that historical context. Also put it into the context of the 2 decades before, like the same lobby or the same growers associations were the ones that lobbied farm workers out of most of labor protections in the 1930s laws that protect like general workers. So we're speaking about minimum wage, overtime, union rights. You may know that farm workers were explicitly excluded from those protections. So when the H2 program was created, we still had the Bracero program, which you may be more familiar because that was happening here in the West. In the East, they do still had a Bracero program, which was a federal program, but they had other binational agreements with Caribbean workers. So we had like Barbados, Bahamas, Trinidad and Tobago workers coming onto these kind of binational agreements. The H2 visa differs because it's not a binational agreement. So we are like ruling out any negotiation with countries that are sending workers. So that's kind of the framing. It becomes really a visa category. So I was talking to Leland and I would refer like to the visa system that he was just explaining. I see it kind of like a caste system, right? Because the United States has created so many categories that label people that can come or not come or for how long into the US. So as Leland was saying, the H2 visa is a non-immigrant visa or an alien visa, right? So that means that people are not supposed to stay here. They can come, do whatever they are allowed to do, but they are not meant to stay in this country. So this is like a temporary visa. And it was later divided in H2A and H2B. That it was later divided in the 1986 Immigration Reform Law, which is very interesting. I know I don't have that much time, but I will tell you a fun fact that that law, as you may remember, was the one that gave ability to many people that had worked specifically as farm workers to become US citizens or residents and therefore citizens. H2 workers were explicitly, again, excluded from that regulation. Specifically, not all of the H2 workers. Sugar cane workers were explicitly excluded because people lobbied into the understanding that sugar is not a produce. Sugar is a dessert. Therefore, H2A workers that worked on the cane field for many years were excluded for getting like the asylum or whatever you call it, you know, like provision, the amnesty, right? The amnesty provision to become. Anyway, that's kind of that fun fact. And just very briefly, H2A visas and H2B, which is the current division of the H2 visa program, they differ in several aspects. As with everything that I told you about immigration, like each visa has their you can and you cannot. So for example, I'm on a J visa because I'm a PhD student, I forgot to say that when I introduced myself. So I have some things that I can do that another like student that may come on an F1 visa cannot do because we have like different things that I can do or not. So H2A workers, they must be provided housing. H2B workers do not. Housing standard is like another issue that we take another panel, but H2A workers, getting closer to my topic, are eligible for an ACA plan, like for health care.
You said ineligible?
They are eligible.
They are
eligible, but H2B are not. And H-2B can be hired for more than a year through a like administrative procedure. But I mean, there are like difference for each one of them. So that's kind of, I hope, like a general overview of it.
So what do we know about how the lives of H-2A workers and how sort of their, I think you put it, contained or controlled through this H-2 system? Like what does that look like for their lives?
So for all H-2 workers, how it works is that an employer has to ask by name for each H-2 employee. So that means that in my petition, that's kind of a long process, but I asked for Lidia Munoz, I asked for Leland Baxter to come and work into the U.S. And when they come and work into the U.S., they can only work for me, unless they enter like on a violation of their contract. So this really means that the experience of the H-2 workers is going to depend almost on its entirety on the ethics, values, practices of the employer. So it's kind of a luck of the draw. If you get like a nice employer, which there are, then you are probably going to have a positive experience. If you get like a very bad employer, which there are, you're going to have a very bad experience. Why is this? Because, and this is what you were referring as a term of total institution, H-2 workers come here to work for an employer, but that employment visa becomes the regulating aspect of everything in their lives. And we are speaking about food, housing, transportation, access to other people, access to resources. And I mean, it's kind of a wide panel of options, but you may have an employer that they tell you, this is what you're gonna eat every day, and they provide the food. You don't like it? Too bad, right? Speaking about consumers, right? Like I'm sure nobody here is forced to go to Walmart, right, for their shopping. They can choose Walmart, Target, the little store, the dog store, or whatever, right? For H-2 workers, it doesn't work that way. Because most of them, and especially for H-2A workers, which are farm workers that are usually isolated in rural areas, the employer will provide transportation. And most of the time, he's not gonna make a poll of like, where would you like to go to do your grocery shopping today? So he's gonna take them to Walmart, right? And many aspects of their life get completely controlled by the employer, including talking to people. Like part of my research was like talking to H-2 workers in Oregon. And I have text messages that they say, I'm sorry, my employer did not give me permission to talk to you. So it sounds ridiculous, you know, if I had to ask the U of Oregon, which is technically my employer, for permission to talk to you today, right? When we put it in terms of our own lives, it just really doesn't make sense.
So we're getting into it. Can you tell us a little bit about what your research is about and how you see this as a consumer protection issue?
Yeah, I didn't think about it as a consumer protection until last year when I was invited to the same panel, and it really got me thinking about workers. I've already told you that workers are seen as agricultural workers and also as immigrants, which are usually not one of the categories that are not like really high on like enforcement of rights, right? These are like really vulnerable populations. So it got me thinking, these are agricultural workers and these are immigrants, and you know, it's very difficult to enforce their rights. But these people are also consumers of health services. Can they be protected? Can we protect them through a consumer protection lens? And I got very excited and very like, oh yeah, maybe, right? So so then I applied for the grant, you know, and I basically, my goal was to identify what was the health experience of workers in Oregon, H-2 workers in Oregon, and how much will they perceive themselves as consumers of health. You know, like, because in Mexico or other countries where most people come under an H-2 visa, healthcare is mostly state provided still. And also how much information they had about access to health. So that's what kind of I set to do during this year. You want to talk about how difficult it was?
Yes, absolutely.
So I've been working with H2 workers for, as I told you, for a long time. And I know that because of these restrictions and this idea of being completely controlled, sometimes it's very hard to talk to workers. But I was not expecting how hard it will be. Like I've talked to workers in many places of the US, but I didn't know one single worker, H2 working in Oregon. So in my research plan, I said I'm going to go to Mexico where the recruitment agencies and where the visa processing takes place, and I'm going to ask permission for recruiters to talk to workers. I know a few of them. I'm going to ask them if they bring workers to Oregon. And unfortunately, the people that I know, none of them brought workers to Oregon, but they knew people that will bring workers to Oregon. So I tried to lobby my way into those agencies, completely unsuccessful. I was literally told, we cannot allow you to talk to our workers. Which, again, it's not that I needed permission to talk to them, but usually workers are way more willing to talk to me if they feel like they are not doing something to kind of upset their employer or the recruiter. So then I tried through the organizations here in Oregon, that do work with farm workers. And to my surprise, a lot of them told me, we do not know any H2 workers. And I'm like, okay. So a lot of and of course, I didn't went to every single advocacy organization yet, right? But a lot of the organizations that do advocacy work with similar populations like immigrants or farm workers do not do any work with H2 workers. So my last resort, and it really was my last resort, I tried really to work my way up to doing it, was getting the DOL list of housing units and going housing unit to housing unit to interview workers. I did not want to do it because of my IRB thing, right? I didn't want like an angry employer saying, why are you here? Let me sue the University of Oregon, right? And then I didn't have to do that. I did get to do like some interviews with foreign workers to the moment in which I make a cut. But I did get kicked out of several other camps. Employers telling me, you are not allowed to talk to my workers on my property, right? So even though I wasn't like on the fields, I was on their renting, which is not rented, on their housing unit. So it was like very difficult. Access to them was very difficult. And to get to talk to me about their experiences was very difficult.
So I apologize, we got a little bit of a late start because of the late end of the fire. We're running a little bit over time into the next, I think there's a session starting right now. So I just want to, I think, close with one thing that you had noted is that at the heart of so much of consumer protection, one of the main issues is the ability to make informed choices. And a choice doesn't matter if after you make the choice you can't follow through on it. And it's hard to imagine a choice being relevant if you don't have information. And so can you just, touch on how that impacts with healthcare and what you're seeing?
Well, yes, I think the main, I haven't processed the interviews, but one of the main thing is that workers know that they do not know. They do not know how the system works in the US. They do not know how services are billed. They do not know what a sliding scale is. They, more than anything, do not know that they are eligible for an ACA plan. They do not know how they get enrolled into an ACA plan, right? So, but also most significantly, this information mostly comes through the employer. So even if the solution, we have a very obvious problem, we do not have information provided to H2 workers. So it was our immediate thought would be, well, let's provide information to the workers, right? But how do you do that in a system in which workers are not even allowed to talk to somebody without the employer's permission, right? So I would say, for solutions, I hope some of you may help me. Wink, wink. And I think that it's really important that we look to immigration as a two-sided coin, right? And H2 workers are kind of like the dark side of the moon, right? They are there, but they are not as present on the immigration debates. They are not as present on enforce their rights. So I think that unless they are protected,
we will also have more protection for other workers that are coming here maybe without documents. So that would be kind of my last time, you know, I really got like goosebumps when you were giving your initial speech, you know, and then Professor Liz and then Attorney General, you know, and something that I wrote down is like, this is about dignity and helping people live with dignity and joy. I don't see that happening for HD workers. Professor Liz said, everybody should be treated fairly and honestly, and I don't see that happening for HD workers. Attorney General says we need to protect those who need our help, and these populations need to be advocated for. They are not going to do it by themselves for many reasons that we do not have the time to explore now, but I link, you know, like any other organization that has the ability or that wants to join me or any other, you know, in advocating for these workers. Because this year we have more than 3,000 coming into Oregon. And Oregon is one of the states that brings less workers. North Carolina brings 3,500. I mean, not 3,500. 35,000.
Yeah, 35,000.
That one. So anyway, that's.
All right. Well, thank you so much, Lydia. Thank you, Bryce, and thanks everybody for